SJC-08772, Commonwealth versus Colton.
Mr. Traff, good morning.
Good morning, Your Honor. May it please the Court, Michael Traft on behalf of Nicholas Colton. Criminal responsibility defense is one of the most difficult in a criminal case because there is an inherent bias among the jurors against wanting to come back with a not guilty verdict. There's the assumption that the individual is responsible for the crime. And there's a concern among the public, and not without some foundation, that the Commonwealth will not adequately protect the public safety of the citizens when someone is given a not guilty verdict on that basis. So that's why it is important for this court, in these kinds of cases, to carefully review the fairness of the trial. And I suggest there are several issues in which this case was not fair and requires a new trial. Let me first address the motion to suppress the statement.
Has there been a motion for new trial?
The motion for new trial has not been filed yet. I will be filing one that relates in some respect to this motion to suppress. I think there's enough evidence in the motion to suppress and the argument that I raised that would justify a reversal of the motion to suppress on the evidence in the case. And this is what we...
Was this tried in 2000? When was it tried?
Yes, it's about 15 years ago. But in terms of the statement, I want to make clear that I'm not waiving the mental illness issue with respect to all of the statements that were made by the defendant. But the critical issue is the statement that he made to the police at the second time, after they had he had given an account that the police were readily able to determine was not true, and came back to him, brought him back to the police station, and confronted him by saying, well, I think what you told us before is not accurate. And then he at least had the presence of mind to raise the issue with the police officer, asked to talk to him alone, and say, do you think I need to talk to a lawyer? Now, what the trooper says is, well, I can't advise you, but your uncle is here, and you can talk to your uncle about that issue. Now, what the trooper knew, and Mr. Colton did not, is that the uncle had been working with the police to provide evidence to the police about this crime. And the uncle had a dual interest here because he was also related, his wife was related to the victim.
Didn't the uncle testify in the motion hearing?
Yes.
And didn't the uncle say something to the effect of, I couldn't believe what was happening and I didn't want to believe my nephew? Because he's related to both victim and defendant, of course.
Right, that's correct.
And didn't Judge Spurlock credit what the uncle had to say?
Yes, I think the problem with what the uncle had to say is he kind of steered it away from what must have been the confrontation. There's two parts of it. One is that Nicholas must have asked his uncle, what do you think I should do? This is what he said to the police officer.
But when you say must have, was there an affidavit saying that he did?
Yes, and there's testimony through what he said, what he related to the psychiatrists about exactly what happened during that confrontation, which is why the psychiatrist found that he was not acting voluntarily. Part of the reason, apart from the fact of the mental illness that was pervasive.
What did the uncle do wrong?
Well, what he was not an advisor. And certainly as a person, I think the problem is that he was trying to, he was placed in a position as being an advisor to give proper advice to this, to his nephew as to what to do.
Wasn't acting as an attorney.
No, he wasn't acting as an attorney, but that wasn't how the defendant perceived it. Not
What do
as
you
an
think-
attorney, but
what
as
do
an
you think-
advisor on his
What
interest.
should the trooper have done, in your view? I mean, he's right, he can't advise him, so what should he have done?
No, I don't think it's improper for him to refer him to the uncle. I think the problem is with what happened in the conversation with the uncle. The uncle first, the one thing that the uncle clearly did wrong is he brings up the whole issue of a death penalty. Now, no one's ever talked about a death penalty to this defendant, but he brings up the issue of the death
Well,
penalty.
whose fault is that? What the uncle talks to the nephew about? I mean, do the police have any control over that?
Well,
They shouldn't be in it, right?
Well, I think what the police officer did wrong is he knew that the uncle was not going to be a neutral person, that he had an interest in trying to get the defendant here to make a statement.
Well, he wasn't a juvenile who has a right to the participation of an interested adult. I mean, he was 19 years old at the time, right?
Yes, and he had severe mental illness, and he had raised the issue about whether he should see an attorney.
But didn't we have two judges listen to two sets of psychiatrists, a psychologist testify and say that they didn't credit that defense, that all the hallmarks of voluntariness were met with the statement?
That's what they determined, and I'm suggesting that determination was improper under the circumstances because of the raising of the issue of the death penalty. That's the concern that.
Did the, and I am sorry, I haven't looked at this, but the way that I read when the uncle said to the trooper, I thought he was saying his only concern, that is,
The defendant's only concern.
there was the death penalty.
Right.
If there, at least I take from what you said that how we know anything about that conversation was through what he told the psychiatrist, right?
Well, the uncle also talked about that fact, and the
So
trooper did.
But did the defendant tell the psychiatrist or anybody that he never mentioned the death penalty, that the uncle raised the whole issue?
Yes.
Okay,
And the uncle did too, as a matter of fact.
okay.
He said that he had talked to somebody in the hall who talked about a death penalty. He thought about it because he's thinking about the fact that the body is found on federal property. Now, we who is involved in the system, I think it's unlikely that this would become a federal prosecution. But Nicholas Colton doesn't know that, who's never been involved in any kind of serious crime.
But the police officer dispels that, correct?
Well, not exactly. Because what he says is, if you cooperate, there won't be a death penalty issue.
Doesn't he just say
We're
there's no death penalty? It's a
There's
state-
no death penalty in Massachusetts prosecution. He doesn't say there's no potential death penalty in this case because that would be false. There is a possibility, maybe a remote one, but there's a possibility if a body's found on federal property, this could be a federal prosecution, which could involve a death penalty. Now, as I say, we're skeptical. It wouldn't, probably as a practical matter, that wouldn't happen, but Nicholas Colton doesn't know that.
But that line of cases where the police give someone the wrong legal, this is your last chance to talk, you'll never have a chance to present your case, that type of case, that's not what we have here, right?
Well, what you have here is raising the alarm that if you don't talk, you may risk a severe death penalty. as a
But the
possibility.
uncle is not the police agent here, though, right? So how is the government responsible for whatever it is that the uncle tells the nephew?
Well, I suggest that he is a police agent to some extent, because he had been working with the police to feed them information, including information. There was an issue about a bat that supposedly was hidden by the defendant. He found out about it, he told the police about it, told the police to talk to this person. So the police knew that this uncle was working with them, and he had a dual interest. So he wasn't really, was he deputized? No. But is he working for the benefit of the prosecution to ferret out information?
Was he asked to do that?
No.
Was he asked to get information from his
No.
nephew? He did it on his own?
Yes.
The uncle was present when the defendant was arrested, and they said, "I'll meet you at the police station," ostensibly to support his nephew, correct?
Well, he wasn't arrested. He was brought, to,
But
according to the police, he was brought to the station, and he came there, yes, to support his nephew.
yeah,
And that's really the issue, because he's brought there as a person to support the nephew, but he's really also there to facilitate.
Wouldn't you be arguing it's more coercive if your client had reached out to the uncle and the police said, no, you can't talk to him, let's continue the conversation? Wouldn't that be more coercive?
It might have been, depending on what had happened, but he might have shut up at that point. And that's really the point.
So you're saying that we should treat this the same as if the police had said, if you don't talk to us, you're going to face the death penalty? But if you do, you will not? I'm trying to figure out how this connects, because by the time he began speaking, he was assured that there's no death penalty in Massachusetts. This is not the police saying, the only way you can spare yourself from the death penalty is to talk to us.
They're implying that. And Mr. Colton says that's what his uncle told him specifically. That's what he says to his...
Say the police are implying that?
Implying that there's a possibility of a death penalty if he does not cooperate from there.
Okay, what else do you have?
But anyway, yeah, well, I know, I don't want to spend all my time on that issue, because I have several others. Let me segue into the joint venture issue. The issue that relates to the mental illness is the idea of whether or not Mr. Colton was planned the event as opposed to a sudden explosive action. And there's no basis in this case to establish a joint venture involving Mr. Heyman, who was the other person in the car. The only description we have is from this statement to the police by Mr. Colton about what happened.
No objection to joint venture, right?
Actually, yeah, I think you're right, there was no objection, right. There should have been. And I think it's a miscarriage of justice.
What about the fact that Mr. Hyman was driving, and they left Newton, and they ended up in the woods somewhere?
Well, they were driving around, and according to Mr. Colton, Mr. Heyman gets out of the car, and then this whole event happens. Mr. Heyman has no knowledge of the victim. There's no other evidence that he had any motive to participate in a homicide
No,
or
but
any
there's
kind.
evidence that he might have been involved. I mean, isn't there physical evidence that the victim was standing at some point, so he must have had help getting out of the car?
Actually, that evidence established that he helped after the fact. I think the death occurred in the car. I think the physical evidence is pretty clear that he was
I thought the
mortally
blood
wounded.
flow indicated that he had still been alive when he was outside of the car clutching at the leaves.
Potentially, he could have been alive, but I don't know that there's any evidence that any of the multiple stab wounds had occurred outside.
How do you reconcile the fact that your client is telling anybody that'll listen that he's going to beat up the victim, and then after that, he goes for this long ride with Mr. Hyman driving?
Well, that might provide a motive that he had some animosity towards Mr. Hyman, that my client did, but not Mr. Heyman did, or that he even knew really about what he was talking about. He says he's going to beat him up. Well, that might be a punch. That's not stabbing 80 times. So that's the difference here. Mr. Heyman didn't have any kind of knowledge or any reason to participate. It's a lot. This is a lot, I think, like the Gonzalez case that this court decided in September, where you've had someone who was a driver and who had participated in some way after the fact. There's no question that Mr. Heyman participated after the fact in hiding the body, coming up with the false story that was easily disproven. But Mr. Heyman wisely spoke to an attorney and never gave any further statement. But in any event, the only evidence we have about what happened was from what was in Mr. Colton's statement to the police. And that completely exonerates Mr. Heyman. There's no other evidence to indicate that he had any involvement with it. And that creates the problem because it really dispels the basis for, or at least works towards the Commonwealth's version, that the mental illness was not a spontaneous attack.
Bloody fingerprint?
Bloody fingerprint, easily. There's no question that he helped clean up the car afterwards, and they tried to find a way That fingerprint could get on there anyway, anywhere. There's blood all over the car. In any way, it could have gotten on there. So I don't think that shows that he participated. Not enough to find him guilty. That's why he's pled guilty to manslaughter, and there was no prosecution. I think the fact that they took a manslaughter plea proves my point.
Well,
They didn't
well,
think-
actually, I mean, if he really wasn't involved, do you think he's going to plead to a manslaughter? Why is he
Did.
going to fight it?
Why wouldn't he fight it? Because he was involved unquestionably in the cover-up,
Well,
Right, not accessory after,
accessory after the fact.
that's,
Oh, he was involved in accessory after the fact, yes.
or he pled to the manslaughter, though,
yeah.
right?
Well, sometimes you're in a situation where the prosecution this is the best deal you're going to get. Not every plea by a defendant is by someone who acknowledges
Well, I
in
appreciate
reality.
that, but,
Right.
there's pleas you do for that reason and pleas you don't. It just seems to me that's something at least.
Well, anyway, I think it's beyond the record for us to kind of speculate on that.
I'm sorry.
Let me get to the
Oh, did you say that he had objected to the joint venture instruction?
I don't believe he did.
There's no objection. So why is it a miscarriage? Why would there be a substantial likelihood of miscarriage arising from
Goes to the mental illness.
the joint venture?
Because it really created a problem with the evaluation of the mental health, and that's why it's a miscarriage, because
It goes to
really-
the planning? Is
It
that-
goes to the planning concept, right. Creates a whole issue of the Commonwealth had a sparse evidence of any planning here, so they had to pull a number of things together. And this was one of them that became a big one, the idea that these two people were working in concert. Now, let me get to the jury instruction. There's one other issue that I didn't raise that I want to mention, and that is the inclusion of the presumption of sanity instruction. This was not given originally by Judge Chernoff, and then the Commonwealth raised it again and asked that that instruction be given. It's at pages in the volume of the jury instructions, I think it's 11, pages 242 to 245. And this court has decided in Commonwealth versus Lawson, it was, of course, at this time, you were entitled to get this instruction, but this court has decided in Commonwealth versus Lawson that doesn't make any sense, it should not be given. And then in your recent case of Commonwealth versus Griffin, you found it wasn't a miscarriage of justice. I suggest it is a miscarriage of justice in this case because you have a substantial criminal responsibility defense, and it's another hook that allows a jury to kind of
Could
get
you tell-
away.
I'm sorry, what instruction are you talking about?
I'm sorry. This is the instruction that juries can consider the fact that in society most people are sane, and therefore you can draw any inference that you can from the fact that most people are sane as to whether this person is
Well,
sane.
it only comes up when there's a lack of criminal responsibility defense, right?
Yes.
So, I mean, if you're saying it particularly is a miscarriage of justice in this case because there is a lack of criminal responsibility case, that's true every time it gets said, I think. So it would mean every case is a miscarriage of justice. And I thought, you can remind me, isn't when the court said that in Lawson, it was sort of, shouldn't do this in the future?
That's in many respects true, but it wouldn't necessarily not apply in a case where there's a substantial criminal responsibility defense. So anyway, I wanted to mention that. The other issue that I've raised in my brief talks about on the jury instructions relates to the interrelationship of the use of alcohol and alcohol consumption and mental illness. And I'll just rely on what I've said already in the brief as to why this instruction really wasn't in conformity with what this court has said in Berry and D. Padova. I want to get, in my final time here, to talk a little bit about the Section 33 in my constitutional argument. How different is it really from a person who is a juvenile, who has a brain that is not fully functioning, from a person who has a severe mental illness that's really accepted by all of the psychiatrists in this case. The Commonwealth psychiatrist doesn't go that far. But if you Google the Malcolm Rogers, the psychiatrist for the Commonwealth, and find out what he says in his name, you come up with the quote, "The science of psychiatry is now where the science of medicine was before germs were discovered." And my suggestion is when we're dealing with a criminal responsibility situation, and you have a first-degree murder, by affirming that conviction, it's very unlikely that that person will ever get out of prison. And perhaps it's much more consonant with justice to have a possibility of release on parole at some point in the future when we know a lot more about and know a lot more how to treat mental illness.
All right, thank you.
Thank you, Ron.
Ms. Sylvia, good morning.
Good morning, Your Honor. May it please the Court, my name is Casey Sylvia, and I'm an Assistant District Attorney for Middlesex, appearing on behalf of the Commonwealth. Your Honors, I'd like to deal with the defendant's first two issues that he raised, hopefully just briefly, and then move on to the De Padova instruction. With regards to the motion to suppress, first of all, there were two judges who considered the defendant's motion to suppress statements that were made to the police, and they correctly denied it. As you know, there were two conversations with the police. One was outside Mark Heyman's home, and I don't think there's any question, even on appeal, that the statements made them were voluntary. So the only statements that are issued are the ones that were made at the police department on August 19th. And there are these two apparent grounds on which the defendant argues that the motion to suppress should have been allowed. First of all, I guess the defendant's mental illness was supposedly so pervasive that he couldn't give a voluntary statement. And secondly, that he was supposedly manipulated by his uncle. And these were the same grounds that were raised at both motion to suppress hearings, and they were rejected by both judges who had the benefit of live testimony, at least Judge Spurlock did with regard to the uncle, who had officers present, both judges did, and who listened to experts, as both judges did. And they both listened to the recorded statement made by the defendant. And so I just suggest that there's no need for this court to revisit the rulings that were made by two experienced Superior Court
Can
justices.
you clarify for me, what did the uncle say in his testimony in front of Judge Spurlock?
He said that, so his testimony was very different than what Mr. Colton claimed in his affidavit. And in fact, I'd suggest if you take a look at Mr. Colton's affidavit, it's actually clearly erroneous in several respects, and that might well be why the judges didn't give a lot of weight to it. So what Mr. D'Angelo said was during the course of the conversation with the defendant, when the door was shut and it was just him and the defendant, that he suggested to the defendant he might want to speak to an attorney. And the defendant insisted repeatedly that he did not want to speak to an attorney. He said that he raised the issue of the death penalty, and he asked one of the officers when he returned back to the room.
Who's the he in that
Sorry,
sentence?
Mr. D'Angelo.
He raised the issue of the death penalty first.
No, I'm sorry. With regards to the officers, he raised it. There's some dispute. Apparently, in Mr. D'Angelo's grand jury testimony, he said he raised this issue and said this is the only thing you really need to be worried about. At the motion to suppress hearing, it came across that the defendant raised this, and that was his only concern, was the death penalty. And again, I'd suggest that that really is an issue of credibility that's for the motion judge or judges in this case. But in any event, regardless of what happened and who raised the death penalty, that issue was clarified and it was resolved before the defendant began speaking with police. Because in front of the defendant, his uncle asked the officer about this issue with the death penalty, and the police officer did completely dispel that issue. He said that we're in a state where there's no death penalty, and this is a state-level prosecution. So there was really absolutely no possibility that there was any confusion on the defendant's part. There was no confusion in the statement that was made by the officer in response to that question. And I'd also just suggest that there's absolutely no evidence whatsoever that the uncle was acting as an agent on behalf of the police. This isn't like the case in Murphy where you have the jailhouse informant who has the agreement with the police to provide information to them. This isn't like the case in Commonwealth via Juvenile, which I think is from 1988, in which, again, the DYS superintendent had an agreement with the police to provide information to them. I don't think there's any reason whatsoever, based on the evidence, to believe that the police had any idea how the uncle would advise the defendant. I mean, he could have just as easily said, no, I don't think you should talk to them. I mean, there's this death penalty issue out there, don't talk to them. There's just, I think you would have to have some type of agreement in order for these statements to be suppressed. The defendant also had claimed in his affidavit that the uncle was sitting there sort of prodding him throughout the interview and poking him and telling him that he needed to answer questions. And there's absolutely no indication of that whatsoever on the recorded statement. So again, I think that it's likely that when the motion judges looked at that affidavit, they noticed that there were major discrepancies between what the defendant was claiming and reality. So again, I would just suggest that the defendant was sober, he was alert, he was coherent, he was steady on his feet, he answered questions appropriately, he corrected the officers when they said something he didn't agree with, and he expanded on detail in questions that were put to him. So I think it's very clear that both he grasped the severity of the situation and what was going on around him. And I think it's important that he attempted to minimize his culpability at every turn. His mind was sort of hazy on key details that he, I would suggest, knew were the areas that were most fraught with potential culpability for him. So again, I would suggest that both judges that considered this issue properly denied it.
Do we have all of that in the record? The testimony of the uncle and
Yes, Your Honor, that
that you referred to is in the record?
yes, it is in the record. There's transcripts of it, as is the transcription of the recorded statement by the defendant.
Okay, we don't have the recorded statement itself?
No, that's in the exhibits at the Superior Court.
Okay.
Which I did speak to the clerk, and I saw those exhibits, and they are, I think, available for the court's review.
Perfect, thank you.
With regards to the joint venture issue, I would just say very briefly on that point that if any view of the evidence supports the giving of an instruction, it is appropriate. And I think that it's pretty clear that there was a view of the evidence, in fact, maybe the only view of the evidence, by which the defendant and the co-defendant, Mr. Heyman, were acting in concert and jointly throughout the entire night, leading up to the murder, during the murder, and after the murder.
Is the evidence, in terms of the stab wounds, is there only one? I mean, do we know that it was only the defendant who was committing the stabbings?
I mean, I don't think we know that for sure. Honestly, I mean, I think that that's a pretty fair inference that it was him that was doing the stabbing. That was both what his statement was, and I don't think there's any indication, really, that Mark Heyman actually did the stabbing. I do think there's a possibility, again, if there's any view of the evidence. I think there's some possibility, and this, frankly, is why I do think the Zanetti formulation is a better one, because there's some possibility that you have a jury that sits there and says, listen, the defendant's obviously involved in this. He's heavily involved in this. Do we know for sure he did the stabbing? Well, I don't know. I don't know if I believe his statement, because there are a lot of other things that are untrue in it. And so I actually think that's why the Zanetti instruction is the much better description of joint venture, because it provides for that type of circumstance much better than the previous instruction did.
Now, it went to the jury on a joint venture theory, but what did the jury do?
So there wasn't it was a general verdict. There was
Okay.
not, so it's not clear. I mean,
Clear.
no.
Okay.
I think, though, that it's extremely unlikely that they were considering the defendant as a joint venture as opposed to a principal. And I do think the cases like Norris and Akara make it clear that this court considers the sufficiency of the evidence for the purposes of giving that instruction under the Zanetti formulation. And I think that there's abundant evidence, especially when you consider in light of Zanetti, that Mark Heyman was present at the scene with the intent to do the crime the same as the defendant was. In particular, I do want to point to that the bloody fingerprint. The bloody fingerprint was not something that would have, the way it was argued to the jury, and I think this is a very fair inference, is that when the defendant and the co-defendant, with the co-defendant drive to this dark wooded area 13 miles from the original location, they pull into this lot furthest from the artificial light source. And at some point, obviously, the victim is pulled out of the car. He's pulled out of the car, and as Justice Lank pointed out correctly earlier, he's standing in his own blood. And that's what the blood spatter showed. He had blood on the bottom of his feet, and he had vertical blood splatter going down his legs to the top of his feet. There's also evidence that he was actually fighting for his life outside of the car and that he was grasping at things around him, as evidenced both by the blood on the vegetation around him and the fact that he had vegetation and hair in his hands. So I would suggest that he certainly was still alive when he was pulled out of the car. And I'd suggest the significance of that fingerprint is that when the car door was opened, the light came on, as it does when you open a car door, and that Mr. Heyman reached up and flicked off the light so nobody would see what was going on. And the reason I'd suggest that is because the blood was still wet when the bloody fingerprint made its impression at the light switch.
And this was on the driver's side?
It was towards the driver's side, that's right.
So was it like near the winch? I'm sorry, I just don't, I
Oh,
haven't got to
so when
visualize it.
the dome light in the car, there's a
Up
switch.
top or,
It's in the center, it's in between the two seats, the back and the front.
okay.
And the switch, I believe, is closer to the driver's side, although honestly, you could access it from
But that
either
was
side.
clearly Mr. Heyman's fingerprint.
It was clearly identified as Mr. Heyman's fingerprint, and it was in wet blood. It was not some latent fingerprint that was lifted off of dried blood. So again, I would just suggest, frankly, that the problem that the defendant has is not the giving of this instruction. The problem is the evidence itself. And I think that that's a problem really throughout his arguments. He says that there's sparse evidence of planning, and I think that's only true if you remove all of the evidence that he doesn't like, that he thinks is harmful to his case, and is harmful to his case because it shows deliberate premeditation and intent. So unless there are further questions on those points, I'd move on to the issue with regards to the judge's instruction, the so-called DiPadova instruction. Your Honors, I would suggest that there's no error in the judge's instruction on the relationship between lack of criminal responsibility and the voluntary consumption of alcohol or drugs. Although the instruction given by the judge obviously was not the same one that was given in DiPadova, because DiPadova came down 11 years after the trial.
Was it from the 1999 homicide instructions?
It was similar in some respects, but it was not the same instruction, the same model instruction that was given in DiPadova or Barry. It was the instruction that was given, I think, I would suggest, is quite a bit better, and that it's a correct statement of the relevant law. And unlike DiPadova and Barry, it would not mislead the jury into believing that any use of alcohol or drugs would cause the defendant to forfeit this defense. The instruction effectively told the jury that, and I'm going to read a little bit off my notes because it is a complicated area of the law and I do want to get it right. It told the jury that voluntary instruction or addiction is not by itself a mental disease or defect, that there are situations where a defendant who's addicted to alcohol or drugs is not criminally responsible, and that one such situation is whether the defendant had a mental disease or defect apart from alcohol or drug addiction that caused the lack of capacity. And I would also suggest, and I don't think I said this in my brief, but I think it's fairly clear that when he says consumption and addiction of alcohol, he's talking about it rather interchangeably. He starts out the whole paragraph, this whole instruction, referring to both consumption and addiction.
So what does he say after what the last sentence you read about an exception
He
is?
then, and I'm not reading directly from the instruction, I'm just saying what the import with sort of liberal quotes from it. He also instructed, he said that one such situation is whether the defendant had a mental disease or defect apart from alcohol or drug addiction that caused the lack of capacity, or whether the voluntary consumption of alcohol activated such a mental disease or defect and that caused the lack of capacity, unless the defendant knew that it would activate that mental disease or defect.
Now, this type of latent activation language, has that been reviewed by this court in the past?
So there is a footnote in DiPadova saying that that this court felt that it was not the best language, that it was confusing. I would point out that I think that that was on the second try, though, that the second stab that the court took at these instructions, because it is a challenging area of the law, and I don't mean that in any way that's derogatory. I just mean this is a challenging area of the law, and that it's something that even this court initially.
You could use the word struggles with.
I don't think anyone's going to disagree with you.
It's a difficult area, it is. And so, yeah, there is that footnote in DiPadova saying that this perhaps is not the best formulation. It's not the best language to use, but then the court goes on to use the words trigger or intensify, which I think are basically synonyms for activate or exacerbate. But I think it's clear, even though that word activate and latent was used, that because the judge said as a result of the consumption of drugs or alcohol, it caused the defendant to lose capacity.
And did it go on and say that would be enough unless he knew that that was going to be the effect of the drugs?
It said, it did not give the exact DiPadova instruction. What it said was, if as a result of the activation of that latent mental disease or defect, the defendant lost the substantial capacity to understand the wrongfulness of his conduct or to conform his conduct to the requirements of law, the defendant would lack criminal responsibility. So it is actually pretty close. It's not as...
Actually, it's better if it doesn't have the other part.
Well, he then says, however, if the defendant knew or subjectively had
Okay.
reason to know
Okay.
under the circumstances. Yeah. I do think, though, that it's a lot clearer than the instructions that were issued in Berry and DePadova. I think there are really two questions. One is whether the instruction explained that the mental disease on its own, apart from any drugs or alcohol, caused the lack of capacity, whether it instructed the jury to that effect. And I think the answer is yes, it did in that first part that I read. And secondly, whether the instruction explained the situation where drugs or alcohol pushed the defendant from capacity to lack of capacity. So the situation where he's pushed over the edge by the consumption of drugs or alcohol. And again, I'd suggest that that second part of the instruction pretty clearly does do that. So I think, and also unlike in DePadova, that language regarding the defendant's knowledge of the impact of those substances came immediately after the part about the drugs or the alcohol causing the lack of capacity. So I think it's clear that that is the situation it applies to, and that that it doesn't apply to the situation where there's some drug or alcohol consumption, but that the defendant already lacked capacity. I think the way that this is ordered and structured is quite different than in DePadova, and so it alleviates the concerns about confusion that existed in DePadova. And I think that the ultimate question is whether this instruction would cause the jury to believe that any alcohol consumption or drug consumption would cause the defendant to forfeit this defense. And I'd suggest the overall impact of this would not do that, and that in fact it is a far cry from DePadova and Berry, and that is likely closer to Johnston, where a reasonable juror would not be compelled to conclude lack of criminal responsibility defense would be unavailable in these circumstances. I'd also just address the defendant's issues with regards to the so-called presumption of sanity instruction. I did note that that instruction was given. It was obviously not objected to because at the time, 16 years ago, the defense attorney did not have the benefit of the case that came out just last month or 2 months ago. That said, obviously the Lawson case is going forward, so I think that the only review is for whether this caused a substantial likelihood of a miscarriage of justice. And I think that like in the Griffith case, which came out at the beginning of last month, that this would not cause such a likelihood of a miscarriage of justice. The Commonwealth here relied upon I wouldn't say they relied upon at all the inference of sanity or the presumption of sanity. Instead, we presented evidence by our own expert. There was vigorous cross-examination of the defense experts, and the circumstances themselves in this case belied the claim that the defendant was not criminally responsible. There was no reference whatsoever in the closing statement to this so-called presumption of sanity, and so I'd suggest that in these circumstances, that there's no likelihood of a miscarriage of justice as a result of this instruction being given. So I would just, in conclusion, I would just echo something that the prosecutor said in her closing argument, and that is that this case is really about choices and it's about decisions. It's not about a fit of uncontrollable anger that rendered the defendant not responsible for his actions, that it's about choices and decisions that were purposeful and that were deliberate, and they included that decision to stab the victim 86 times while he fought for his life outside that car. So I'd suggest to the court, for the reasons cited in my brief and for that reason, that the convictions were appropriate on the grounds of both deliberate premeditation and extreme atrocity or cruelty, and I would ask you to affirm the defendant's convictions. Thank you.